The Supreme Court on Wednesday broadened the ability of religious organizations to hire and fire employees without offending federal anti-discrimination laws, affirming that the Constitution provides freedom to choose who teaches the faith. In a 7-2 decision, the court strengthened the ministerial exception it found in 2012 that protects religious organizations from some employment lawsuits. It said 2 teachers at parochial schools who wanted to contest their firings in court were the kinds of employees who were covered by the exception and thus unable to sue. It indicated that those involved in almost any kind of religious instruction would be considered ministers of the faith, no matter their official title or even if they practiced the faith themselves. Justices Sonia Sotomayor and Ruth Bader Ginsburg dissented, saying the decision gave religious employers free rein to discriminate. Judges on the U.S. Court of Appeals for the Ninth Circuit in San Francisco had said the teachers could proceed with their lawsuits against Catholic schools in California. Agnes Morrissey-Berru alleged age discrimination against Our Lady of Guadalupe School in the Los Angeles area. In the other case, Kristen Biel sued St. James School in Torrance. She said her firing after a diagnosis of breast cancer violated the Americans with Disabilities Act. Biel lost her battle with the disease last year, and her husband, Darryl Biel, had taken her place in the lawsuit. But both performed vital religious duties, said Justice Samuel A. Alito Jr., who wrote for the court's majority. The religious education and formation of students is the very reason for the existence of most private religious schools, and therefore the selection and supervision of the teachers upon whom the schools rely to do this work lie at the core of their mission, Alito wrote. Judicial review of the way in which religious schools discharge those responsibilities would undermine the independence of religious institutions in a way that the First Amendment does not tolerate. Conservatives on the Supreme Court have been more broadly supportive of religious rights and organizations. Last week, the court ruled that states that aid private schools may not exclude religious ones. But in the case decided Wednesday, Justices Stephen G. Breyer and Elena Kagan, usually part of the court's liberal bloc, voted with the majority. The teacher cases ask the court for further guidance on when an employee of a religious organization should be considered secular and, thus, able to take advantage of anti-discrimination laws, or religious, and thus unable to do so. In a unanimous decision in 2012, the court said the ministerial exception meant that a former teacher at a Michigan Lutheran school could not sue her employer. The key, Alito said, is the Constitution's protection of the free exercise of religion.